Hi, everyone. I ended up being a couple minutes late because somebody was being a little bit barky, and so she must have known I wanted to do something. So yeah, I'm just trying to get her to settle down. She napped for a really long time before this, so now of course she wants to play. But this is justice for anybody who doesn't know, and yeah, she's being a little difficult. So. So I'm sitting way far away from my computer, and hopefully she'll settle down in a minute. Maybe she'll just lay down in front of me this whole time. So it's all Justice's fault. I was actually a couple minutes early, and then she started barking, and I had to chase her around and get her. And so that's typical, though. You know, she's just like a kid. Yeah, always acting up at the worst possible time. So, okay. I am sorry, first off, that it took me so long to do the video. Honestly, it's been a lot. It's been a lot going on, obviously, and a lot to deal with, a lot to take in. And I just needed to not think about it for a little while. And it was hard for me to get into research mode. But I did. And so hopefully I can give you a very good understanding of the Brady violation here and the law on Brady, which actually, when we're done, is probably going to be clear as mud because, you know, everything's contradictory. But I want to just present all the information, the laws, what Kathleen presented, what she cited, what the statutes are, what the case law says, and then, you know, several cases that are pertinent to what she's presenting. Again, if anybody doesn't know by now, I don't really talk about the actual content or, you know, case discussion, and so don't expect any of that because I don't do that. I did that a long time ago. I don't do that now. Now I just stick to the legal stuff because everybody else talks about the case. Nobody else does this. So that's why. And I talk enough, and it's long enough as it is, so it doesn't need to be any longer. So I think I have a few people here to start at least. So we'll get started. And I can't even see my notes. I am working off notes. I have 4 pages here because I am going to be using a lot of citations, and please, I can't remember them, but that's for sure. So I just want to make sure that I make sure I'm citing everything correctly and that I don't skip anything and it is kind of all over the place, so hopefully I can keep it straight as I'm talking, but forgive me if I don't. If I jump around too much, just let me know. The material is a little bit on the dry side. It's not real exciting stuff I'm talking about here. It's interesting if you're into the law, and that's about it. Otherwise, it can just be kind of tedious. So if you're bored, just say you're bored, and I'll try to move along faster. But I'm hoping I can make it somewhat interesting and that you'll get something from it, because it is interesting from a legal standpoint, and especially when you're trying to figure out, does this have any merit? And it absolutely does. There's no doubt about it. Prior to this motion being filed, I was very worried about the Brady claim. And there are still some concerns just because the case law is a little irritating in some areas. But I think it's stronger now than it was prior to filing this motion. And I have to say first, because since I'm always criticized and yelled at for being a basher, I think this motion was excellent. I really do. I think that she did present the case the best possible way she could with the information she had. And somebody just messaged me. Yes, I am live. Thank you. And I think that she put a lot of good case law that supports her arguments. I think that, okay, Justice, you're going to say goodbye to everybody. Here, say goodbye. Say hi, goodbye. You're not going to look at the camera, are you? Say hi and goodbye, because I'm putting you down because you're being too squirmy and it's making things difficult. So, okay, but you're not going to bark, right? You're not going to bark? You can be a good girl? Okay, say bye. Okay, throw all her stuff down there. Okay, now I can get more comfortable. Okay, so what I'm going to start with is Brady violations in general. And one of the things that people don't completely understand, because they hear Brady violation and they hear that the prosecution has to disclose information to the defense. And that's not completely accurate. Okay, the Supreme Court has actually said numerous times that the prosecution does not have to turn everything over to the state. I mean to the defense, and that they are not required to have an open file policy, open folder policy. That's not how it works. And people shouldn't message me right when I'm doing this. So what does qualify under Brady and under disclosure obligations? Okay, so what it has to be is that the information has to be, number one, potentially exculpatory, or something that would impeach a witness's testimony or impeach their credibility. Now, when I say impeach their credibility, that means that you have to be able to discredit. It has to be information that could potentially discredit a witness, basically make them not as good of a witness. You need that information if you want to argue against some of their testimony. So if it's something that could discredit a witness, then it needs to be turned over. That's not the only thing, though. And one of the things they stick in there is that it's whether it's inadvertent or advertent. It doesn't matter whether they meant to or not. It doesn't have any bearing on it. And the other thing is what it's called materiality. And it says that it has to be, this information that was withheld has to be material to guilt. And that's important for what we're dealing with. So it's the first one and the second one that are most important. Now, when the prosecutor doesn't have to turn over everything that they have, then who's to say what they're supposed to turn over? And this is where it gets a little irritating, is that it actually is up to the prosecution to decide if it's exculpatory or not, if it's impeachment material. Now, clearly, there wouldn't be Brady violations if they always did it, decided correctly. But that is how it usually works. They are supposed to, be the ones that say, yeah, we know this is exculpatory, we have to hand it over. And again, it's going on the basis from when this law was created. Some of this law was created 100 years ago, before everybody knew that lawyers could be, unethical and immoral. And actually, Berger versus United States is the one that covers this. And it says, the prudent prosecutor will resolve doubtful questions in favor of disclosure. This is how it should be. Such disclosure will serve to justify trust in the prosecutor as the representative of a sovereignty whose interest in a criminal prosecution is not that it shall win a case, but that justice shall be done. Isn't that a great sentiment? That sounds wonderful. But we live in the real world, and that doesn't always happen. And this is why Brady violations occur, because you have prosecutors who do care more about winning a case than justice. And it's not just in this case, it happens a lot. And so this is why Brady violations occur. Yeah, Wendy, lawyers are never unethical. I know that. I don't know what I was thinking by that. So, I said, it's a beautiful concept, but it's just not realistic. Okay, so in Brady versus Maryland, that is the definitive case involving Brady violations. Obviously, they're called that for a reason. Now, what I wanted to talk about originally, or the first, is the first part. With Justice is growling at something behind me. I don't know what she's doing. Nobody else is here. I don't know what she's doing. Again, the number one rule to satisfy Brady or a violation is if there's evidence that's withheld from the defense that is favorable to the defendant because it is either exculpatory or impeaching. She's over my shoulder watching. Okay, so this is something that when you look at the DCI report and you read what's in it, and you can tell right there in black and white, they did not turn over this CD. We're all aware of that. And it would be nice if that's all that mattered. Can you hear her growling? She's crazy. So what the problem here, and what my original reservations were about this violation or potential violation, is that the case law is actually pretty clear that it isn't that making the defense aware of something is in most cases enough to satisfy the disclosure obligation or discovery obligation under Brady. And there's a couple little things that would make a difference. Now in the DCI report, oh, you can't hear her? Okay, good. In the DCI report, when they first mentioned the CD, they just say that it's a CD with web searches and images on it. If they had left it at that, it would fall under Brady, absolutely, because how would the defense know that that was important? They wouldn't. But at the end of the DCI report, they say exactly what is on that CD. And it says that it has graphic images of violence and porn and murder and all sorts of horrible things, and these searches. And my belief in what the case law suggests is that that would be enough to satisfy their disclosure under Brady. And the reason being that the defense has to bear some responsibility for defending their client. And if the prosecution makes them aware of something and they miss it or they don't request it, that's on them. That's a failure on their part. And that's why I was screaming since November about I couldn't understand why she wasn't filing it as an ineffective assistance of counsel claim. Because to me, is, cover your butt. If it doesn't fall under one, if the reasoning is that it doesn't fall under Brady because the defense should have known about it, well, then it should fall under IAC. Because yes, they should have known it. And the law states that if the defense should have known about something through exercising due diligence, then it's not on the state that they didn't have that information. And so I'm going to go through some of the case law on this, and it's under Strickler versus Green, or Strickler versus Green, which Kathleen actually did cite in the original petition with regards to other Brady violations, but she left it out of the motion for reconsideration and the motion to correct the record, and this one. This is probably why. Okay, so in Strickler, I have to explain these cases, and that's what always takes so long. In Strickler, the Cliff Notes version, there was a man who abducted a woman from a parking lot, and she was later raped and murdered. Okay, and there was a witness to this crime. And yeah, I'm probably not, I see some questions already, but is IAC a better approach? Not necessarily, it's just that it's a fallback option for sure. I don't know which one's better, but since you're allowed to file both, you might as well, because like I said, it should fall under one or the other. And it's possible that it won't fall under either. It just depends on how they evaluate it. So, but I probably won't be answering too many questions while I'm talking, but I'll try to look over every once in a while, because everybody can tell by now I lose my train of thought really easily. Okay, so anyway, in Strickler versus Green, there was a witness. And at the trial, this witness was amazing. She was a star witness. She remembered every detail. She remembered why she was at the mall. She remembered what store she was in, who she was with. She remembered what time this happened. She described the victim. She described the perpetrator. She did everything. She seemed like an amazing witness. And during the trial, she even said that she credited, her testimony to having such a great memory. That's why she knew everything. Now, in the pretrial discovery, there were references to pre-trial interviews with this witness, with this woman. And there were some notes included and some interviews included. Well, it turns out after the man was convicted, it was discovered that there were a lot more notes, and there were several more detective interview reports that had been missing. And these notes made it clear, as they got increasingly more obvious, that this woman didn't remember anything. She didn't remember much of anything. And she even says that she thanks the detective for helping her fill in the gaps of her memory. And she says that, oh, I talked to my friend and she helped me remember. Well, I was watching the news last night and now I remember more. She essentially got her entire testimony from media, the detective, and other people, which would have been important information to know during the trial, because again, Brady, covers impeachment material. So it seems like, hey, obvious Brady violation, right? Not so much. Okay, so what happened was that after the conviction, he filed a petition for post-conviction relief. It was denied. It went to the Court of Appeals. And this was the ruling from, I believe it was the Fourth Circuit. And it said, the Brady claim was denied because the factual basis for the claim was available to him at the time he filed his petition. Given that he knew that the witness had been interviewed by police officers, the court found that reasonably competent counsel would have sought discovery of the police files. And that, in response to this simple request, it is likely the state court would have ordered the production of the files. So what they're saying is that any decent defense team would have read that there were these pre-trial interviews and would have requested them. That was what they were saying. And then there was another ruling that was based on this Fourth Circuit ruling in Stockton versus Murray that held that a party cannot establish cause to excuse his default if he should have known of such claims through the exercise of reasonable diligence. Again, saying that you can't do your job terribly and not exercise due diligence and not do a good investigation and then cry, oh, Brady violation afterward. You can't do that. You have to do the best that you can to find this information, seek it out. And then the final citation is aware of the existence, and this one is really pretty spot on. Aware of the existence of potentially exculpatory information, a defendant cannot sit idly by in the hopes that the prosecution will discover and disclose that information, and when the prosecution does not do so, seize upon the prosecution's conduct as grounds for relief. So again, it's saying if the defense is aware of potentially exculpatory information and they don't request it, they can't expect the prosecution to do their job for them and hand it over. It just doesn't work that way. And so this is what really gave me pause about the Brady violation, because it is in the DCI report and it does say exactly what's on that CD. Now, I'll get to where a little wrench is thrown into that and why I think it's stronger now in a minute. But to go back to Strickler for a minute, the Supreme Court actually overruled the Court of Appeals decision, which sounds good, right? Well, they overruled it for a very specific reason. And they said that in the discovery material, it stated that there were pre-trial interviews and notes. That is correct. That was in there. But since some interviews were in there and a couple notes were in there, there is no way the defense could have known that there was more. They were not aware that there were 4 more notes and 3 more investigative reports. They had no way of knowing that. So how could they request it? And that's why it was overturned. So it wasn't overturned because they were saying, like, no, they don't have to be aware of it. They're saying that even though they were aware of it, they weren't aware of the number of notes and information. So therefore, how can they have asked for it and requested it? Okay, so that's how that case went. Yes, it is. And that's the thing that gave me, everybody was saying this Brady violation is such a slam dunk. And I said that unfortunately the case law says the opposite. It really does. And it seems unfair, and it probably is, but that's what it is. And that's why I'm like, I don't want, that's why I kept telling everybody I didn't want to do that video. I didn't want to say it because I knew everybody was so excited about the Brady violation. And I just thought that the case law supported it not, prevailing, under the first rule. And but now other issues have come into play that may call it into question, and that's a good thing, because obviously I want this to succeed, and it really just upset me when I was reading all the case law and it's like, crap, this isn't making me happy. Now we also have U.S. versus Bagley, which you'll hear me talk about more because that is a big case when it comes to materiality. And it says regardless of request, meaning whether you request it or not, favorable evidence is material and constitutional error results from its suppression by the government if there is a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. Okay, so now we're almost contradicting what they're saying in Strickler. Shocker, laws contradict each other. That it's saying now, regardless if you request it or not, they said if there's a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different, it's a Brady violation. Yes, Miriam, there is. I'll get to that. Don't get ahead of me. Okay, so moving on. See, I'm trying to think of where I want to go next. Okay, we're going to talk about NAPU versus Illinois because that is a case that KZ cited. And it's a big case that's always cited when it comes to Brady violations. Now, in this case, the prosecutor failed to inform the jury of knowingly false testimony. And again, this is the one thing in this case law that is not completely on point with what we're dealing with or what we're looking at. So again, it gets a little hard to gauge how good the claim is when the case is not completely on point. And it's very hard to find a case that's completely on point because obviously every case is unique, the circumstances are unique. So it's really hard to say. Now this is, again, basing it on the fact that the state knowingly used false testimony. And there was another case that I talked about in my group Long, what was it? I can't remember now. Long versus Pfister, that's it. That was just decided last year, and it was the same type of case. It says a principle that a state may not knowingly use false evidence, including false testimony, to obtain a conviction does not cease to apply merely because the false testimony goes only to the credibility of the witness. Okay, so even though we don't know, or I don't know how hard it's going to be to prove that Kratz would have known that testimony was false, because that's hard to prove. It's still saying that using it doesn't mean that it can only be used if the evidence is used to be false. Okay, if it's made up evidence, false evidence, okay, that means that obviously under that law it's going to be thrown out. But in what they specified in NAPU is that they're saying that that goes along with testimony as well. So witness testimony that's false, that's false. And that if you have information that goes towards the credibility of that witness, that also falls under Brady. And I'm sorry that I just mix that all up. Sometimes when I'm reading and then I try to, that's why I'm better when I just talk. And that's what I usually do. But there's so much information here that I don't want to miss anything. No, yeah, cases are almost never directly on point. It's really inconvenient. The jury's estimate of the truthfulness and reliability of a given witness may well be determinative of guilt or innocence, and it is upon such subtle factors as the possible interest of the witness in testifying falsely that a defendant's life or liberty may depend. Okay, everybody understands that, correct? What they're saying is that the reason that it's material when it's impeachment material is that the jury, they're looking at this witness and they're deciding if this witness' credibility is good and whether their testimony is indicative of guilt or innocence. So when there are details, even if they're minor, that may call that credibility into question, it's important. Even if it's something tiny, any type of credibility issue is important and it's valid because the jury is deciding if these people are worth believing or not. And so that's why they're saying it's important that that false testimony falls under Brady, because it is just as important as physical evidence to determining whether somebody is guilty or innocent. Okay, so that's pretty much what they're covering there. And I believe that Kathleen actually used that citation when she said that the truthfulness and reliability of a given witness may well be determinative of guilt or innocence. And that's why it's important when you have all of the information in order to impeach a witness. Okay, then yeah, Eric, I think I'll kind of cover that. Correct me, but I didn't read that. But didn't I read that they said Brendan's computer had no incriminating evidence, therefore Avery's defense didn't follow up? Yes, that is in there, and I'll get to that. You guys always get ahead of me, man. Okay, I know I'm boring, but come on. Oh, stop growling at me right now, please. Okay, so another big case is State versus Harris. And this is from the Supreme Court of Wisconsin. It's not a U.S. Supreme Court. It's a SCOW case. Okay, so Harris is a 31-year-old man with an 8th grade education who has a history of serious mental illness. In 2001, he was accused of sexual misconduct, alleging that he had sexual contact with a 13-year-old girl. He ended up pleading guilty in his case. He tried to plead not temporary insanity, but that he was mentally ill. Didn't work, and you heard that growl, yeah. It didn't work, so he decided, he looked at everything, he knew he did not have the evidence to support his innocence, so he decided to plead guilty. Is Taylor here? Is she on? So what happened was that Harris filed a post-conviction, he was sentenced, and then after sentencing, he found out that the victim had actually made a previous allegation against her grandfather for sexual assault on 2 occasions, and this was never disclosed to the defense. Again, clearly knowing that information, since she was the only witness against him, could have made a difference in his deciding to plead guilty or not. So he filed a post-conviction petition to withdraw his guilty plea. And that's, again, that's an important part of this, because that is the thing that takes it off point, because we're not talking about a guilty plea. We're talking about, in this case, we're actually talking about the events leading up to a Denny motion. Here they're talking about up to a guilty plea. So again, I'm just trying to make this easier to understand. I don't know if I'm succeeding or not. Okay, so the court concluded that we determined that the allegation against her grandfather is the type of information the state was required to disclose because it constitutes evidence favorable to the information, favorable to the accused whose non-disclosure undermines our confidence in the judicial proceeding. Messed it up again. I can't read. It says that this is the type of information the state was required to disclose because it constitutes evidence favorable to the accused whose non-disclosure undermines our confidence in the judicial proceeding. This information is favorable to the accused because it constitutes impeachment evidence that casts doubt on the credibility of the state's primary witness. Again, sounds completely on point to what we're looking at here. The only difference is that in this case, they're arguing that he should be allowed to withdraw his guilty plea. What Kathleen's doing is saying that this information would have been vital to their Denny motion. Clear as mud, Lori. I know I told you, just wait, it gets better. In this case, they also said, we further hold that such information must be turned over within a reasonable time before a trial. There you go, Miriam, we're getting to it. The state was obligated to disclose this evidence at a point when Harris would have had sufficient time to make effective use of the information. Again, as I said before, they disclosed this information after he pled guilty and after he was sentenced. So yeah, pretty clear that he wouldn't be able to use it when they disclosed it after he's sentenced. Now the key point here, hi there. The key point here is that it says such information must be turned over within a reasonable time before trial. I hate those little specifics in there because that is what complicates things. Because on the surface, it sounds like that applies directly. But Kathleen is not saying that. She's saying it should have been allowed prior to the Denny motion. It doesn't say anything in the statute about it being allowed for a pre-trial proceeding. And that's where it's like, what are they going to do with it? I don't know. So then it gets even more confusing because right there it's like I get excited because I see, hey, this is exactly what we're looking for. And then I see that word trial and I'm like, that's not exactly what we're looking for. And then I see more and then it's like makes me feel happy and then I go down again. And so this is why I'm just throwing it all at you and you decide your level of happiness when I'm done. So KZ argues that the defense didn't have enough time to have a forensic analysis done of the DVDs because it was disclosed only 22 days prior to the due date of the defense's Denny motion. The first request for discovery was actually made by Eric Loy, who's one of Steve's earlier attorneys. And he made that request on February 1st of 2006. The Denny motion was due January 11th, 2007. So they had 11 months to turn this over. and they didn't. Now, KZ mentions the fact that Buting and Strang made a second request, but if you paid attention to the dates, their second request was on January 18th. Again, the Denny motion was due January 11th. And actually, they filed it on about January 8th, I believe, if I'm remembering correctly. So that second request was too late. But it should have still been made before trial. Because possibly they could have renewed their Denny motion or amended their Denny motion. I'm not really sure. But I would think that they would be able to if new information was given to them. I don't think you're just out of luck because they didn't give you the information on time. So, but what she's arguing is that they could have made a better case in the Denny motion if they'd had this information, mainly because the judge had said that Bobby wasn't a legitimate suspect because they could not show motive. And KZ's argument is that this CD, the information on the CD, the search terms and all those things goes towards motive. And then she goes into this long thing about Dressler and about possession of pornographic material, and honestly, whatever. I don't even want to go into all that stuff. That's not as important to me as this case law. So, okay, so now I'm still thinking like, okay, so is it sure? Oh yeah, Wendy's saying that I'm sure they could renew. Yeah, I think so too. I don't know why you can't when you get new information and trial hasn't started yet. You should be able to, but that's all in the past. So who knows? They didn't. So now, then this brings up the case. It's the case of Ruiz in the U.S. Supreme Court. And they ruled there that due process does not require the disclosure of material exculpatory impeachment information before a defendant enters a plea bargain. To me, that is just crazy. I can't even understand that logic, that we could have impeachment evidence that's very important to your defense, but we are not required to disclose it before you enter a guilty plea. What kind of crap is that? Seriously, that doesn't even make sense. Like, how can you make an informed decision about taking a plea agreement when they're not even required to give you all the information? It's completely nonsensical to me. And I was reading that and I was like, what? Are they kidding me? But that is what the law says. And it's actually not just in Ruiz, it's in several cases. So they're saying that just because we said that they have to turn it over in a timely fashion prior to trial, that doesn't mean it has to be, prior to filing a guilty plea. What they said was that the guilty plea was entered 2 weeks before the trial. So that is probably when it should have been disclosed, at least 2 weeks before trial. They don't give a specific date. They say it should be disclosed in a reasonable time frame, but they don't tell you what a reasonable time frame is. When you're talking about legal terms, yeah, try to figure out what they mean by reasonable time frame. Anywhere from a week to a year for anything. I mean, you have to be clearer about this stuff because how is anybody supposed to know what's considered reasonable? Like I said, in legal time, yeah, good luck trying to figure that out. So this at first was like, great. They're being very specific. They're saying it's before trial. Again, we're talking about a Denny motion. But then the case law turns again and says that, but if you specifically request discovery material under the statute 971.23, then they are required. If you make a statutory demand for discovery pre-plea agreement in this case, then they are required to turn that information over in a reasonable amount of time. Okay. It's like on a roller coaster ride. Like I said, it seems like good news and then bad news and then good news again. So again, the question is that same reasoning going to apply to a pretrial motion? It would be lovely if it was the exact same situation, but it's not. But I believe that, oh my God, I don't know what she's doing. She just crashed something. I believe that if they're saying that a statutory request makes a difference, then it shouldn't matter what the proceeding is. It should mean that if you're making a request via statute, they should turn it over in a reasonable amount of time. It shouldn't matter for what you want to use it for. That's my thinking. Whether it's right or not, I have no idea. I'm pretty sure my dog is destroying something. She doesn't like it when I don't pay attention to her. So she destroys things when I don't. Oh, she's so lovely. Okay, so the big question in this motion is about Kratz lying. Does that turn everything on its head or not? Because Kratz lied when he said that the computer didn't have much evidentiary value on it. Okay, first thing I'm going to say is that Dean Strang filed an affidavit saying he took him at his word. WTF. Are you kidding me? That was one of those jaw floor moments. Are you kidding? Why would you ever take the prosecutor's word? Ever. Especially when you're talking about a case where you're presenting a frame-up defense and you're alleging misconduct all over the place. Oh yeah, Ken, we're just going to take your word for it. You seem like a good guy. Are you kidding me? Okay, sorry, but that just enraged me. I could not believe that he even said that. I took him at his word. Why would you ever do that? This guy had made a press conference that was so clearly unethical that it already pretty much prevented your client from having a fair trial, and you're just going to take him at his word when something says it doesn't have much evidentiary value. Not to mention the word much being in there. Because I don't care if they said it didn't have much. I'd be like, well, what does it have? If they said it had no evidentiary value, well, I still would have asked for it. But the fact that he said much, it was like, well, it's still question what's on it before I stipulated to not needing the information. Okay, I gotta get that out. Now, the report is also inaccurate because it says that there are 6 disks when there were actually 8 disks. It also attributes the computer belonging to Brendan, which is what the defense thought. This was Brendan's computer. And it was not Brendan's computer, we now know. I think that Kathleen has established enough evidence to show that it was not Brendan's computer. Okay. The thing is that one of the reasons, and it's important because one of the reasons why Buting and Strang may not have wanted to know what was on it was because it was Brendan's computer. They already knew that Brendan could potentially be used as a witness against them. But until that point, they even put this in the stipulation. They said, if Brendan is called as a witness, and if you are planning on putting him on the stand, then we may want to look at this. So we're not stipulating that we don't ever want to look at this. And the reasoning could be deniability, basically. If something was found on Brendan's computer that would have implicated Steve, then they would have been better off not knowing. Okay, now the argument would be, well, if there's something on there that implicated Steve, well, you'd think that you'd know because the state would be all over it. But whatever. But they did plan on, if it was going to be used, you know, if Brendan was going to make a statement or was going to testify against Steve, they still wanted access to that computer, probably to see if there was any potentially impeaching information. No matter what, as a defense attorney, you should want all of the information. Even if it ends up looking bad for your client, you should want and you need all of the information available, period. So, sorry, Buting and Strang, but that is, I can't wrap my head around that. I can't comprehend just saying, nah, we're good. We're not going to look at it. I don't get it. You should want to know everything you can when you're defending somebody. Okay, so this brings us to, so what I was going to say about those things, sorry, was that the lying about it and the fact that they misrepresented things adds an extra layer to this claim that I'm not sure what they're going to do with that. It'll be interesting to see. Now, the lying does somewhat come into case law when Kathleen talked about Kyles versus Whitley, which is, she even said, the leading case in materiality. And in that situation, it was the same type of situation with regards to the fact that the prosecutor lied. Now, he just flat out lied and said there's no evidentiary, there's no exculpatory information. That's it. They requested it. They put in Kyles versus Whitley, they actually put together this long discovery list of what they wanted, and the prosecution's only response was like, nope, we have nothing exculpatory to give you. Sorry. So it is a similar in the fact that they lied. In this case, this case is so egregious that it's just, it almost makes the guy's case pale in comparison about the level of tunnel vision and just how much they ignored. This case, okay, there was a woman who went grocery shopping. She was attacked when she was getting into her car, and a struggle ensued, and she was shot in the head, and the man took off in her car. That's the gist of it. There were around 6 eyewitnesses to this, and wouldn't you know that all 6 eyewitnesses described this guy differently. He was everything from 5'4" to 6'1". I think that they'd always described him as being African American, but some said he had bushy hair, some said he was bald, some said he had braids in his hair. It was all over the place. Hi there. It was all over the place, and they took notice of all the other vehicles in the area to see if maybe the person had brought their own car and then took off in the victims. And they really didn't have a lead in the case until this good Samaritan that he is called and said, hey, this guy I know just sold me this car that sounds like it's this victim's car. And it turned out it was. It was an LT, whatever. And this guy, his name was Beanie, if that tells you anything. I don't even know his real name. They say in the beginning, but they refer to him as Beanie through the rest of the thing. If you know anything about the Adnan Syed case, Beanie is Jay. Okay, he is a direct clone of Jay. He changed his story over and over and over again. He kept just making things up. It's so obvious he's making things up. And to me, again, yeah, I know I was an investigator, but do you really have to be an investigator to say, like, why is this guy being so helpful? Could you think of a reason of why he could be so helpful? And he was even asking about the reward money. But he put his friend Curtis Kyles, as the person who sold him the vehicle. And at first that was it. He sold me this vehicle and I'm worried about it. But then it became, oh, I saw him with this woman's stuff and he was acting funny. I saw him with a gun. He just changed his story over and over and over again. And the story was so what's weird about it is that when the investigator said, no, we don't have any exculpatory information, their entire case was built on this guy giving them all this information. And they never told the defense about him. Any of his numerous interviews, none of the claims he was making, nothing about the car being sold, they told them nothing. And to make it worse, when they went to trial, they didn't even use his testimony. Because clearly they knew that he would be a terrible witness because he kept changing his story. But they still tried to prosecute him on this. And it ended up in a mistrial, which should tell you something. Because even with these 6 witnesses and everything else going on, it still ended in a mistrial. So when the mistrial happened, the investigators went to Beanie and got another statement for him that completely changed again. And they still didn't inform the defense that they had been talking to this guy. And it's so bad that they had 2 witnesses. So when they did the second trial, they had 2 witnesses that, just like Kratz did, that Kathleen pointed out, these 2 witnesses were described in the closing argument of the prosecutor as his star witnesses. You have to listen to them more than everybody because they are the ones that are important. Well, one of them described, the perpetrator as being 5'4", 5'5", and 150 pounds. Curtis Kyles was 6'1", I believe. The person, and very thin. The person who was 5'4" and 150 pounds was, shocker, Beanie. They also said that the person who did it had braids in his hair. Kyles didn't, but guess who had braids in his hair? In the second trial, they even got a witness for Kyles. So first of all, he had an alibi. He had an alibi witness saying he wasn't there. And then they had another witness that said, hey, just so you know, I saw Beanie like driving that car just a couple hours after the crime. And yeah, he had braids in his hair then. And I saw him hanging out at Curtis's house, and I saw him bending down by the stove where the murder weapon was found. And I saw him out by the garbage cans where the woman's purse was found. And the only thing tying Kyles to the case was a small receipt that was found in the woman's vehicle. But Kyles had said that he and Beanie had gone to the grocery store and he'd bought a couple things, which would account why he had a fingerprint on this receipt. The woman he supposedly murdered had gone and done her weekly shopping, so she had a list, this long, and yet that receipt wasn't around. The funny thing is, though, of all the other stuff they found, the groceries, the grocery bags, the gun, everything, they never compared Beanie's fingerprints to any of it. Go figure. So anyway, this is a very, like, an incredibly egregious case as far as I'm concerned. That how can you even, like, prosecute somebody like that? And not only did they prosecute him, but his conviction was upheld. He was sentenced to death. So yeah, a serious case. He was sentenced to the death penalty, and his case went all the way through the state courts. He filed a petition for a writ of habeas corpus, just like Brendan did. And it was overturned. And as a side note, it was a close decision. It was a 5-4 decision. And I want to bring this up because it's what I talked about when I was talking about Brendan's petition, about the decision on the petition, was that the biggest problem, well, other than EDPA, was that the Supreme Court doesn't usually look at fact-specific cases. You can't get a more fact-specific case than this case. And they still heard it. And the reason there was a 5-4 decision, and there was a scathing dissent from Scalia, shocker, where he was just like, this is not what we do. We do not decide factual information. That is not what we do. This isn't even about a matter of law. This is about a matter of whether we believe who the killer is, and we don't do that. He actually said, what we have here is an intensely fact-specific case in which the court below unquestionably applied the correct rule of law and did not unquestionably err, precisely the type of case in which we are most inclined to deny cert. He was very adamant about it. And he even went so far to say that he believed their decision would be overturned if there was a higher court to go to. And that would be another case where you'd sit there and say, what the hell? How could they not overturn that? I mean, it's so obvious that this case was mishandled, and because of they don't take fact-specific cases. And I will say, this was actually a pre-EDPA case as well. It was a year before EDPA. So that's how big of a deal, like I said, it is when they say they don't take fact-driven cases. And that just, again, is why it was so hard for Brendan. Oh, hi. Yeah, I've been going on for a while, I think, already. Yeah, too long already. I'm losing people. I've already lost like 10 people. Sad face. So, but again, I know it's a little bit late, and I know that I'm boring. So sorry. Okay, I am on the last section already, though. Yay for that. Okay, so another case that is very important to materiality is U.S. versus Bagley, and that's the one that I mentioned a little bit before. And let's see what I said about Bagley. I don't know what I said. Oh, I didn't say it yet. Actually, I skipped this part. That's why. Let me find it again. Okay, so when it comes to materiality, they're saying that evidence being exculpatory is not enough. Okay, it has to be potentially exculpatory or impeaching, and it has to be material to guilt. Okay, again, this was another thing that I was worried about, because Kathleen is saying that the CD is material to the Denny motion, which in turn is material to presenting third-party liability, which then in turn could be material to guilt. But you're taking a few steps along the way. And again, these laws are not, they don't do that. Usually it's like it has to be material to guilt. And, you never know what they're going to do with that exactly. Now, so a few things to say about U.S. versus Bagley, which talks a lot about materiality. Oh, I did mention Bagley before when I said that regardless of request, if information is favorable, it has to be turned over. Yes, I knew I mentioned it before. Okay, so a showing of materiality does not require demonstration by a preponderance of the evidence that disclosure of the suppressed evidence would have resulted ultimately in the defendant's acquittal. Kathleen puts that in the motion. You do not have to prove that this information would make your client innocent, or would show that your client's innocent, or would have changed the verdict to an acquittal. That is not the burden that they have to reach here. They have to reach what is called Yeah, I know, Wendy, that Wendy is going to tell me that might be too big of a stretch. I know, and that's why it concerned me. Because, you never know if they're going to want to go outside the lines that much. But, okay, so what Bagley says, and the test they use, is what's called the reasonable probability standard. And essentially that says, and this is in the motion, you guys have seen this, what that says is that if the withheld information had been presented at trial, is there a reasonable probability that there could have been a different verdict? In other words, what they're saying is that reasonable probability is a probability sufficient to undermine confidence in the outcome. Okay, so that is the burden that has to be met with materiality. Okay, so she does not have to prove that this information shows that Steve is innocent. She doesn't have to even come close to proving that. She has to show that this information would make it reasonable to think that there could have been a different outcome. Let's see, I have actually touched materiality is a reasonable probability of a different result. The question is not whether the defendant would be more likely than not to have received a different verdict with this evidence, but whether in absence he received a fair trial, understood as a trial resulting in verdict worthy of confidence. A reasonable probability of a different result is accordingly shown when the government's evidentiary suppression undermines confidence in the outcome of the trial. And again, what they're saying in there is the same thing I said before, but what they do is that they take this one piece of evidence that's withheld. They measure it up against to all the other evidence presented at trial. Now, we, the supporters, will look at it and say, well, that's garbage because we already know the key was planted and we already know the bullets, crap, whatever. Well, that's not how the court looks at it. Okay, a jury found this to be important physical evidence. So is Bobby's testimony going to outweigh the other evidence? Meaning that if we could have just impeached his testimony, blown his credibility, would that be enough for there to be a reasonable doubt? And I already know what everybody here would say. Well, not everybody, depends who's watching, but all the supporters, I know what they would say, for sure. Now, this is why this is an important thing that Kathleen did in her motion. And actually the same thing happened in, I think it was in Harris, or no, maybe it was, I don't even know. Probably in Kyle's, I can't remember, but it was the same type of thing. Oh, it wasn't Kyle's, because the same thing that the prosecutor, I just talked about it before, that Kyle's himself had pointed out how important these witnesses were, in his trial. Well, Kratz did the same thing. I don't know if I wrote it down what Kathleen had put in the motion, but Kratz had essentially said that, his testimony is vital. It is important. You need to pay attention to him because he's the last person to have seen Teresa alive. So it would be hard pressed for the court then to say, well, we don't think it was his testimony was material to the verdict because, hello, the prosecutor is even saying that it is. And then she pointed out very smartly that the jury even questioned wanting to have Bobby's testimony to look at. They wouldn't do that if they weren't questioning something. So again, if you could have impeached that testimony, especially the very damning testimony of the fact that, Teresa didn't leave the property, kind of a huge thing. The jury requested to review Bobby's statement. We know it was denied. In my opinion, the jury considered it important as well. Well, yes, they wouldn't have asked for it if they wouldn't have thought, if they wouldn't have been having something they needed to sort out. We don't know what part of the testimony they wanted because the court sent it back to them saying, hey, we can't give you entire testimony. If you can narrow it down, we'll help you out. And they never, as far as we know, they never submitted another request asking for more specific testimony. So we don't know. I wish they had said that so we knew exactly what it was that they wanted to know, because that would be really helpful right now to know that. So when you have, like I said, when you have the prosecutor actually making your case for you, how important this witness was, that materiality shouldn't be as hard to prove. Let me see. I'm just trying to write these other quotes that I said. One does not show a Brady violation by demonstrating that some of the inculpatory evidence should have been excluded, but by showing that the favorable evidence could reasonably be taken to put the whole case in such a different light as to undermine confidence in the verdict. So they say the same thing over and over in different ways. But yeah, they're saying that a Brady violation isn't talking about something that inculpatory that should have been added. It's talking about something that's, or should have been taken out. They're talking about something exculpatory that should have been added. Okay, this is important because this was also something that was addressed in Kyle's. It says one of the aspects of Bagley and the materiality test is that its definition in terms of suppressed evidence should be considered collectively, not item by item. And that's pretty important. That was a very significant ruling. And it was one of the issues in Kyle's that was brought up as well, because if you remember what I said, that they withheld everything. They said, no, we have no exculpatory information. And they withheld not just the statements by that one guy, but they withheld everything they had, basically. And when in the court of appeals looked at it item by item, and they said, well, the fact that he was bending down by the stove isn't enough to overturn a conviction because, who knows what he was doing there. We can't prove that he planted the gun. That's not enough. The fact that he was back by the garbage and that's where the purse was found, that's not enough. The fact that he was, in possession of the car, that's not enough. The fact that he gave an inconsistent statement, that's not enough. And that's what the Court of Appeals was doing. And the Supreme Court was trying to say, like, okay, wait a minute. Like, there has to be a net effect of all of the stuff that's withheld. Because, yeah, one by one, it might not be enough, but when you look at all of it, you can't just ignore that this is a huge gap in proving your case. This is a huge problem. And so they said the same thing in Bagley, where they said that evidence of withheld, Brady material that's withheld can be cumulative. It doesn't have to be just a independent case by or point by point piece of evidence. Now, in Kyle's, though, a lot of it all regarded around the same individual, Beanie. A lot of the withheld information was regarding Beanie. So in Stephen's case, there's more individual components of things, but Kathleen's asking them to consider all of it as a whole and say, like, maybe one of these things in and of itself isn't enough, but look at it as a whole. You look at the fact that they withheld the CD, or they weren't very forthcoming about the CD. You look at it that they made errors in the report, saying that it was Brendan's computer, saying that there were only 6 discs when there are 8. You look at the fact that Kratz flat out lied to them and said that there was not much evidentiary value on the computer, again, saying that it was Brendan's computer. When you put all those things together and more, then Kathleen's saying you need to look at all those things together and say, did Steve have a fair trial based on the law of due process? Because he is entitled to put on a complete defense, and that means having all of the information that he needs to present that defense. And Kathleen is saying he did not have that. And I don't think he did either. And the only thing is that, you tell me, I just read all the case law. If anybody wants me to repeat something, or probably not, but if anybody, but you can see how just in each specific rule that it has to apply to, or that it has to fit, there's case law that's like says one thing and that says another thing, and then since it's not completely on point, you don't know where it's going to fall into, and so it's a mess. And I do think, based on everything here, I just don't know how the state can, or the judge can, deny an evidentiary hearing, because exactly what I'm saying, there's too much information that needs to be sorted out. They need to get to the bottom of some of this in order to give a fair ruling on this. They need to find out why that CD was withheld. Even though it doesn't matter whether they did it purposefully or not, they need to find out why, and I will say this, that I am not above, even though I'm always like, don't scream about corruption and everything. I've already said, I know it happens. I am not above thinking it's possible that, what do you guys, oh my gosh, I shouldn't look at my messages. I don't think it's outside the realm of possibility that Kratz could have played a part in this purposely, because Kratz is not dumb. Okay, he's dumb with a lot of stuff he says now, but as far as an attorney goes and the law goes, he's not dumb. He's immoral and he's unethical. But I could see him thinking, I'm going to fulfill my discovery obligation by telling them about this CD. But then what I'm going to do is I'm going to give them thousands of pages of documentation all at the same time and hope that maybe they don't notice it. Now, it's really hard to prove something like that, but if you think an attorney is above doing that, they're not. Again, sorry, Wendy, but they're absolutely not above doing that. That is where when you're an unethical attorney, you get very good at skirting the law. And so if he would think, no, I know I shouldn't have looked, Tina. I thought maybe it was somebody telling me something, that I was doing something stupid. But yeah, when you have an attorney that is unethical, they get very good at being creative when it comes to the law. And so I could see it. I can see it being that he could say, like, I am going to fulfill this discovery obligation, but what I'm also going to, by telling them about it, but I'm also going to give them so much material and they only have 2 weeks to sort through it, and I'm just going to hope they don't notice, which is clearly what happened. Another thing that is cumulative to this is the fact that Fassbender didn't put it into evidence, and that is, I want an explanation for that. And that is why they should order an evidentiary hearing, because we need an explanation for that. That's not, what you should be doing as an investigator. And they need to answer to that. One thing that I think helps is that the biggest problem that Steve has encountered is the procedural bar issue. But since the state has opened up an investigation and Kathleen is referencing a lot of the new affidavits and new interviews, sorry, not affidavits, but the new interviews, it would be really hard to say that there isn't newly discovered evidence that needs to be evaluated. I just think that they have to have an evidentiary hearing. I think they need to get to the bottom of what happened with the CD and why. And this is separate, completely tangential to the case. But I want to know, and I want somebody to be held accountable for the fact that you have a DOJ investigator that stumbled across a very serious federal crime while investigating a case, and he did not report it. I want somebody to answer for that. Because I'm sorry, I go back to Fassbender thinking about, like, oh, Brendan, I'm not an investigator, I'm a father too. Really? You're a father? And you don't report that you've just found 6,000 images, including child pornography and kids involved in sexual activity, as a crime? Yeah, screw you, Fassbender. Sorry. I usually try to be more professional about that. But I mean, that just blows my mind. And again, how can you say that everything they did is above board? Again, forget about the case. Forget about Stephen Avery, forget about everything. Just look at what happened. They were investigating a crime. They came across accidentally, or while they were investigating this crime, they came across evidence of a federal crime, and they didn't report it. And somebody needs to answer for that. And they better. And Fassbender's number one, Kratz would be number two, because he knew about it as well. But Fassbender kept that CD in his possession. So to me, it's not only failure to report, it's obstruction, because he didn't want anyone else to find out about it. And the thing is that failure to report a crime in Wisconsin is a misdemeanor for most people. But we are a mandatory reporting state when it comes to certain professions. And mandatory reporters include law enforcement officers. And it is a felony to not report a crime when you are a law enforcement officer. So, just saying that. And again, I honestly, I don't care where you stand on this case. If you think that's okay, then you're definitely biased, because that is not okay under any circumstances. I don't care what case you're investigating. A law enforcement officer overlooking a federal crime that is a felony, is disgusting. It's absolutely disgusting. Oh my God, I can't even repeat that out loud. Anybody knows about a certain guilter that says certain things. Are you kidding me? Go look at the statutes in Wisconsin about who mandatory reporters are. Yeah, right in there, police officers and law enforcement officers. People think about, healthcare professionals or counselors or anybody that works with children, teachers, principals, things like that are considered mandatory reporters. Well, you know what? So are law enforcement officers. For this very reason. because once they're investigating one crime, it's very easy to find another crime. And if they're failing to report it, that's a problem. Yeah, it's a felony for any mandatory reporter to not report a crime. I can't remember what level felony, but it's a felony. Now, when we're talking about statute of limitations, because I talked about this when it came to the child pornography statutes, right now, a federal child pornography statute, there is no statute of limitations. Okay, it's a state and federal crime, but it's considered federal because it's over the internet. So there is no statute of limitations. But when you're talking about statute of limitations, you usually have to go back to when the crime was committed. And the computer was seized in April of 2006. The Adam Walsh Child Protection and Safety Act was put into law in July of 2006. And that was the law that ended any statute of limitations on federal child pornography charges. So again, the computer was seized in April and the law didn't go into effect until July. So, yeah. And so the same could be true with these mandatory reporting. You know, the standard statute of limitations is 6 years for a felony in Wisconsin, but, you know, there's always exceptions. There's always, you know, different rules. And so I can't say whether that's going to fall under statute of limitations. I really didn't look into it, but I don't care. When you're a law enforcement officer and you don't report a federal crime, a felony, especially involving children and sex crimes, yeah, you're a piece of shit. Sorry. No way around it. You are. So I don't know if there's anything else that I wanted to say about any of this. Does anybody have any questions? I know I haven't been answering a whole lot of questions because I've been talking so much. Yeah, Michelle, I'm amped up. You talk about crimes against children and sex crimes against children. Yeah, I get a little amped up, especially, like I said, when you have a law enforcement officer, especially a person who's with the Department of Justice. This is not some local cop that, you know, he knows better. And I hope Fassbender takes a hit for it big time. They certainly need to take away his Investigator of the Year award. Okay, so is there any other questions? I know that I forgot something. I can already tell you right there, because I was thinking about something as I was talking about that, the statute of limitations issue. And I thought about that, about whether the detective that did the analysis, that is not, he is like I said, he's providing the information. The expectation would be that the investigator would be the one that would report it. He's a forensic analyst. So it's not really his job to report it, because that's something that the investigator is supposed to do. He's just analyzing the crap they gave him. But once they didn't, you know, I think that there probably would have been an obligation to say something. But again, you know, I'm gonna put it on Fassbender first and foremost, above everybody else. You know. Good night, Miriam. So I said, I know there's things I forgot. I don't know. There's so much information, and I'm sorry that it is just a truckload of citations and case law. And please, somebody tell me that it made sense to somebody, that it was helpful in some way, even though I said clear as mud. So yeah, I just stop growling at me. Justice is getting impatient, so I'm definitely going to have to wrap this up soon. And it's been long enough, and I've rambled on long enough. But okay, so really all that stuff, and nobody has any questions about the legal stuff? Can anybody just reassure me that, you know, they paid attention? Okay then. Nobody. Okay. Here, come here. Come here. Come here. If you want to say goodbye to anybody, here, we're going to say goodbye. Okay, stop being naughty. Okay, yeah, I'm not going to deal with that. You guys, keep it out of my group. I told you this stuff about the legal stuff, and just keep anything else out of my group. I don't want to deal with it. I don't, you know, I see enough of it in the other groups, and I just, I want to keep it doing what I do. So, okay, so is there anything else, you guys? Oh, Tammy, one sec. Okay. So the trial court will hear an evidentiary hearing. Well, Eric, that's what they're going to decide. Oh, and people have asked, too, whether the state files a response. The state isn't required to, the one thing the statute isn't very clear on is whether they can file a response on their own or if they have to wait for the judge to request it. Now, in the statute that talks about the state's part in it, they have to wait for the judge to request a response. Kathleen was saying that you know, that you have to request, or that the state should have been heard before she made a decision, and that's definitely not in the statute. So I'm not really sure what it says about, but I know that for a fact the state does not have to respond. It's just like the petition Brendan filed. They can file an objection or a brief in opposition if they want to. No, right now the circuit court, Judge Suckowitz is going to rule on whether there should be an evidentiary hearing on this issue. That is what they're going to rule. She's going to rule. And I can't see how she can deny it with everything that was presented. And again, an evidentiary hearing is just that. It's to ask more questions. And I think there's enough information in this here that some serious questions need to be answered. Again, mainly around withholding the CD and why it wasn't turned over and why Fassbender kept it in his possession. I don't know how a judge can't say that. That needs to be evaluated. Once they have an evidentiary hearing, a PCR hearing is considered an extension of the original trial. So Kathleen can call witnesses, she can, and it has to remain within the scope of what was granted for the hearing. So that means that she can't all of a sudden go into an evidentiary hearing and start, you know, calling witnesses for completely unrelated issues. Okay, the petition, the hearing has to still stick to what's in the petition. She can file supplementary petitions, or she can file supplements to this. She should notify the court. Hello, you know, do not count on the judge taking 60 days to rule. So Kathleen, if you might have a supplement, make sure to notify the court. But it's an extension of the real trial. Other than, the only thing different, there's no jury. You call witnesses, there's an opening, there's a closing, you know, you present evidence. It's, everything else is just like what the trial would be. And it would all be regarding this issue and anything surrounding it. So that's what an evidentiary hearing is all about. Well, you know, I'm going to reserve judgment about how horrible the judge is. Like I said, I didn't agree with her previous decision, but you know, if she doesn't grant an evidentiary hearing, then I will be right there with you when I'm going to say that this judge is just, it's not being fair, because I think that this begs for a hearing. If the judge does deny it, then what happens is it goes back to the Court of Appeals. But now all of this information, all of this new evidence, everything that Kathleen has presented will now be part of the official record, which is what the goal was to begin with, was no matter what the judge rules, getting all of this on the record. And then the Court of Appeals would decide whether a hearing should be granted. And that's another step we just don't want. So obviously we just want the evidentiary hearing to be granted. Once the hearing is held, then the judge makes a decision on whether or not the conviction is going to be overturned and whether he deserves a new trial. So that's the next step, one step at a time. But at least this judge has 60 days. It's not, before we could be waiting 6 months for a decision, you know, or like in Brendan's case, you know, this is 60 days. So we'll see. Seriously, file a notice of intent to supplement. Yes, please. If you're going to change something or add something, please notify the court. So, okay, anything else? I should probably go, because this is like almost over an hour and 10 minutes. It's way too long. Nobody is going to want to be here for more than an hour. People will turn me off. So, okay, I'm going to go. So any other questions and any questions I missed, I'll answer in the comments. So I will talk to you guys soon. Say bye, Justice. Say bye. Say bye. You're so